please call the case.
Bonjour, Monsieur le Juge.
Good morning, Your Honor. Case IT 0586, the prosecuted versus Vinko Pandurevic.
Je salue toutes les personnes présentes.
I would like to greet all those present here, the representatives of the prosecution, the accused, and all those who are here in this courtroom assisting us. I would like to ask the prosecution to introduce themselves. The appearances, please.
Good afternoon, Your Honor. My name is Peter McCloskey, and with me today is Janet Stewart.
Merci.
Thank you. Mr. Pandurevic, can you please stand? I would like to make sure that you are able to follow the interpretation of what I'm saying in your language. In that case, can you please tell me, yes, I can hear you and I can understand you?
Yes, Mr. President, I hear you and understand you fully.
Well, General, I was informed by the registry that concerning, with regard to the assistance of counsel, you've signed a waiver to your right of being assisted by counsel. Under the statute of the tribunal and Article 21 of the statute, it is stated that you are entitled to defend yourself. And under Rule 45 of the Rules of Procedure and Evidence, it is provided for that an accused can have legal assistance if he wishes so, and also that where the interests of justice so require, he can have legal assistance assigned to him without payment by him if he does not have sufficient means to pay for it. Therefore, I would like to know if you maintain your decision, if you still want to defend yourself on your own without assistance of counsel.
Mr. President, at today's initial appearance, I wish to defend myself. That is to say, I don't need the assistance of counsel. The court is going to appoint defense counsel of my own choosing, and I think that this will be done in due course. Thank you. So I am just going to defend myself today and not require the assistance of counsel today, but in future I will avail myself of that opportunity. Thank you.
Very well, you can sit down.
Thank you.
Bien, alors, mon général, avant d'aborder précisément...
General, before moving on to the procedure provided for by Rule 62, let me briefly recall a number of facts relating to this case. We have an indictment that originally had been drawn up against three co-accused, Mr. Radislav Krstic, Mr. Vinko Pandurevic, and Mr. Vidoje Blagojevic. The indictment was numbered IT 98-33-1. In a confidential order issued on 2nd of November 1998, the confirming judge, who in that particular case was Judge Momba, the judge confirmed the indictment I've mentioned. Later, on 3rd December 1998, the accused Radislav Krstic was transferred to the tribunal in order to be tried. On the 2nd of August 2001, the same accused was sentenced at trial to a sentence of 46 years in prison. He appealed the sentence and the conviction, and his sentence was reduced to 35 years by judgment issued by the appeals chamber on 19th of April 2004. in a confidential and ex parte order of 26 October 1999, the confirming judge, Judge Mumba, allowed the prosecutor to amend the initial indictment and to file amended and separate indictments for each one of the three co-accused. On the 27th of October 1999, the prosecutor filed an amended indictment against the three co-accused and three separate amended indictments against each one of the three co-accused. On the 7th of December 2001, the amended indictment against Pandurevic was made public. On the 23rd of March 2005, the accused Pandurevic, who is here in this courtroom, was transferred to the detention unit of the tribunal. On the following day, on the 24th of March 2005, Judge Liu confirmed a new indictment dated 10th of February 2005, case number ICTY 05861, against the accused Pandurevic. This indictment included new charges, and the confirming judge ordered the prosecutor to withdraw the amended indictment dated 27th of October 1999, and the new indictment was served on Pandurevic, on the accused Pandurevic, today, 31st of March 2005. Let me sum up the indictment. At the beginning of July, of the month of July 1995, units of the Drina Corps that were part of the VRS, the Bosnian Serb army, shelled Srebrenica and attacked United Nations observation posts that were located in the safe area and that were manned by Dutch troops. Later, the VRS forces entered Srebrenica. It is stated in the indictment that on the 18th of July 1995, the VRS forces placed under the command and control of Ratko Mladic, Radislav Krstic, and Vinko Pandurevic deported or killed most of the members of the Bosnian Muslim population in the Srebrenica enclave. The VRS forces practically eliminated any Muslim presence from Bosnia in that particular region of the Srebrenica enclave, thus pursuing the ethnic cleansing campaign that had been started in the spring of 1992. According to the indictment, from 12th of December 1992 to November 1996, the accused Pandurevic was the commander of the 1st Light Infantry Brigade of Zvornik, the Zvornik Brigade, as it was called, in the Drina Corps of the VRS. He was promoted to the rank of general of the brigade in June 1997, and he is a member of the General Staff of the VRS, and that was the case until April 1998, where he was relieved from his functions. The accused Vinko Pandurevic, according to the indictment, and on the basis of individual responsibility provided for by Article 7.1 of the Statute of a Tribunal, and/or on the basis of his responsibility as a superior, according to Article 7.3 of the Statute of a Tribunal, is charged with 2 counts of genocide, Article 4 of the statute, genocide and intent to commit genocide. Is charged with 4 counts of crimes against humanity, Article 5 of the statute, extermination, murder, persecution, and inhumane acts. And he's charged with 1 count of violation of the laws and customs of war, Article 3 of the statute, in that specific case, murder. This being said, I would like to recall that in an order issued by the President in December 2004, this case had initially been assigned to Trial Chamber 3. Then, following a new order issued by the President of the Tribunal on 23rd of March 2005, the case was assigned to Trial Chamber 2, which I'm a member of. Following an order issued by the President of the Tribunal on 24th of March 2005, I have been appointed as the judge of the Trial Chamber 2, in charge of the initial appearance. I am going to move now to the procedure of the initial appearance as it is provided for by Rule 62 of the Rules of Procedure and Evidence. I'd like to ask you to stand, General, because I have to ask you a number of questions now.
Pouvez-vous me donner...
First of all, can you please give me your name and first name?
My name is Vinko Pandurevic.
Pouvez-vous m'indiquer votre date de naissance?
Could you inform me of your date of birth and place of birth?
I was born on the 25th of June 1959 in the municipality of Sokolac, Bosnia and Herzegovina, today the Republika Srpska.
Quelle est votre profession actuelle?
What are you by profession?
Avez-vous une activité?
Are you currently employed?
I am not doing anything at the moment. I was a professional officer, and I was General Major by rank and by education Doctor of Sociological Sciences.
Bien, on va passer en audience.
Very well, we will go into private session now, Mrs. Registrar.
Nous sommes en audience publique, c'est les juges.
We're in open session, Mr. President. Judge Antonetti, General, I have to ask you whether your family has been informed of the fact that you are in The Hague, and if that is not the case, would you like us to inform your family, or is your family aware of the fact?
Mr. President, in view of the fact that I voluntarily and with the help of the Serbian government gave myself up to the detention unit, my family knew about this decision of mine and is fully informed of the entire case.
Bien, je vais vous...
Very well. Could you please sit down now? Madam Registrar, it is necessary to read out to the accused Articles 20 and 21 of the statute. We will now read out Articles 20 and 21 of the statute to you. Article 20, commencement and conduct of trial proceedings. The trial chambers shall ensure that a trial is fair and expeditious and that proceedings are conducted in accordance with the rules of procedure and evidence, with full respect for the rights of the accused and due regard for the protection of victims and witnesses. 2. A person against whom an indictment has been confirmed shall, pursuant to an order or an arrest warrant of the International Tribunal, be taken into custody, immediately informed of the charges against him and transferred to the International Tribunal. 3. The trial chamber shall read the indictment, satisfy itself that the rights of the accused are respected, confirm that the accused understands the indictment, and instruct the accused to enter a plea. The trial chamber shall then set the date for trial. 4. The hearings shall be public unless the trial chamber decides to close the proceedings in accordance with its rules of procedure and evidence. Article 21. Rights of the accused. 1. All persons shall be equal before the International Tribunal. 2. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute. 3. The accused shall be presumed innocent until proved guilty according to the provisions of the present statute. 4. In the determination of any charge against the accused pursuant to the present statute, the accused shall be entitled to the following minimum guarantees in full equality. A. To be informed promptly and in detail in a language which he understands of the nature and cause of the charge against him. B. To have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. C. To be tried without undue delay. D. To be tried in his presence and to defend himself in person or through legal assistance of his own choosing. To be informed, if he does not have legal assistance, of this right, and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it. E. To examine or have examined the witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions under witnesses against him. F. To have the free assistance of an interpreter if he cannot understand or speak the language used in the International Tribunal. G. Not to be compelled to testify against himself or to confess guilt. Thank you, Madam Registrar. General. Have you taken note of what has just been read out to you, namely Articles 20 and 21 of the statute? And have you understood the sense of what has just been read out with regard to your rights? Microphone for the accused, please. Yes, I have
to follow, and I can tell you that when I arrived in the detention unit, I was given the statute of the tribunal and instructions with regard to rules of procedure and evidence. I was read out this article so that I was apprised of my rights in advance. Thank you.
Bien. Avez-vous...
Very well. Have you been provided with the indictment in your own language? You should have received a copy of the indictment this morning.
Mr. President, I should like to inform you of several facts. When I arrived in the detention center of the Hague Tribunal, I was given two versions of the amended and supplemented indictment. The date is the 27th of October, 1999. And I also received on the 30th of March, that is to say yesterday, the indictment, the new indictment in English, which is not signed And today at 12:45 hours, I received the translation of that indictment on the basis of what you have just read out and the several articles. I am conscious of the fact that it is the English version indictment that I received yesterday, and today a copy in a language I understand.
Très bien.
Very well. Have you understood the indictment?
In view of the fact that I spent the last few days focusing on the two variants of the amended indictment, the final indictment I received today, so I have not had a chance of studying it fully. And I should like to ask the court's indulgence and pursuant to Article 62, Para 3, that I state my views within 30 days, and also that I have a certain time to lodge an appeal. I would like to consult a defense counsel of my own choice. The appointment process is underway, and I hope that it will be settled positively soon.
Very well. Would you like to have additional information with regard to the indictment?
I don't think there's any need to waste time reading the indictment. I think that I have your guarantees that it is indeed the indictment that I have been given, that it is identical to the one you have, so I can read through the indictment myself, and then I should like to plea within the deadline that is provided for. It is not for any obstruction purposes, but merely to realize my rights before this tribunal so that the process can go ahead.
Alors, justement, pour faire respecter vos droits,
in order to respect your rights, pursuant to Rule 62 of the Rules of Procedure and Evidence, I should usually read out the indictment to you. However, you may waive the right to have the indictment read out to you if you believe that it is not necessary. However, if you don't want to waive this right, I can read out the indictment, which consists of 13 pages. Would you like to have the indictment read out to you, or will you waive your right to have the indictment read out to you?
There is no need for you to read out the indictment. I can read it myself in a language I understand, and I hope that I'll be able to understand it when I come to do so.
En vertu de l'article
Pursuant to Rule 62 of the Rules of Procedure, you have the right to enter a plea, to plead guilty or not guilty, and you can do so either immediately or within 30 days. You have just told me that you would prefer to wait for 30 days in order to thoroughly study the indictment and to confer with your defense counsel. That is, in fact, the gist of what you have just told me.
Yes, that's precisely what I said. Yes, that is precisely what I asked for.
de votre souhait.
Very well. I take note of the fact that you would prefer to wait for 30 days before informing us of your final decision. It will be necessary to see you again. After the 30-day period has expired, to see what your final decision is. There are two hypotheses. There are two possibilities. Firstly, if an accused enters a guilty plea, in that case, the date scheduled for trial must be indicated. If the accused pleads not guilty, then a pretrial judge is appointed, and the pretrial judge summons the accused and his counsel every 4 months in order to discuss the proceedings and the stage at which the proceedings are. You mentioned the possibility of filing a motion for provisional release pursuant to Rule 65 of the rules. And I would also like to point out to the prosecution that pursuant to Rule 66AI, it is their obligation to disclose to defense counsel and to the accused a copy of all the supporting material which accompanied the indictment when confirmation was sought, and this must be done within 30 days of the initial appearance of the accused. And I would also like to inform the accused that according to Rule 72A of the rules, once the prosecutor has disclosed all the material to the accused, within a period of 30 days, he has the right to file preliminary motions if he has the intention of contesting the indictment. This is the procedure that we will be following. I'll now turn to the prosecution. At this point in time, is there anything the prosecution would like to say?
No, Your Honor.
Bien. Alors, mon général.
Very well, General. Would you like to take the floor? Are there any issues that you would like to address?
I don't think there's any need. I have understood everything you have told me and explained to me, and I hope that I will appear here in 30 days' time to enter a plea.
Enfin, dernière question.
Very well, and my final question that I have to put to you. Since you have arrived here, is everything fine in the detention unit? Do you have any problems as far as your family is concerned? Can you phone them? Are there any particular requests you would like to make, or is everything in order?
I have had no problems. Everything was in conformity with the rules governing the detention center.
Bien, dans ces conditions, je...
Very well, in that case, the procedure pursuant to Rule 62 has been respected. You have been informed of all your rights, and you will take advantage of the 30-day period to decide how you will be pleading. As a result, I will now adjourn this hearing. Thank you.
All right, for you, full effect.